And you're waiving Mr. Jones's appearance today?
Yes, sir.
Okay, and I know just been handed a motion for continuance of hearing, so. Is that on the defendant's amended motion to disqualify the assistant state attorney?
The hearing on that particular motion? Yes, sir.
Okay, this is from the state.
Yes, sir.
All right, well, I'll tell you what I'm gonna do. I'm gonna deny that because I'm ready to rule. So I'm gonna deny the defendant's amended motion to disqualify the assistant state attorney. I've reviewed obviously all the materials and we've had discussions on the record about this before. Mr. Fusco, I see no law that would require the court to grant the relief or make it appropriate to grant the relief that you're requesting. This is not a situation that you're asking for the court to disqualify the entire state attorney's office. Your motion is directed at disqualifying a specific assistant state attorney. Given the facts of this case, I don't see where your remedy lies with the court. Your remedy lies with the building next door and Ms. Owens's boss, the elected state attorney for this circuit. Chapter 27, I think, governs the statutory authority of the state attorney's office and the assistant state attorneys who work for the state attorney. You obviously make some rather serious allegations in your motion. I'm not making any findings one way or the other about those. I'm just suggesting to you that your remedy lies there and potentially with the Florida bar if you believe it to be appropriate. Any attorney can certainly make those remedies available to them as well if they believe it to be appropriate. And the court's not making any findings one way or the other about that as well. Again, I'm just to make it clear, I see no applicable law here that would mandate the court granting the relief that you're requesting, particularly in light of the fact that the evidence adduced before the court was that given the charge in this particular case that the assistant state attorney in question, Ms. Owens, arrived at the scene of the alleged crime after it had allegedly already occurred. So for those reasons, the court is denying the relief that you're requesting. Okay, where are we at?
Yes, sir. I guess proceeding to scheduling the motion to suppress that was filed as well as some motions in limb, but the state may not disagree with the motions in limb.
Okay, as far as the motion to suppress, that appears to be the most pending or the most
Yes, sir.
time sensitive.
Right. I believe it's a dispositive motion, Your Honor. It essentially attacks all aspects of it, from the traffic stop itself to the prolonged detention, the investigation, probable cause to arrest, 4.5 hours later, and everything thereafter.
Okay, Ms. Owens, you agree?
I
That's what we need to
agree.
schedule that?
Yes,
Yeah.
that's the next hearing to schedule, Your Honor. I do have a final pretrial still to be heard this week. And because of that, would Your Honor be agreeable to setting that to be set next Monday?
You good with that, Mr. Fusco? I know we have our trial date of August the 29th. We'll obviously see how realistic that is as we get closer.
Yes, sir. I have a potential jury selection scheduled in front of Judge Ruth Monday to be set. Shouldn't be a problem. I don't know what day that trial will go. Does the court have any availability the 15th, the following week, just to play it safe?
I mean, that's fine with me.
I'm more likely to be in a first degree murder trial on the 15th than the week of the 8th, but it's fine with the state as well. I just.
Well, why don't we do this? Why don't we just go week to week, since right now we've got the trial date pending, and obviously if everybody's schedules don't work out, so let's go August 8th to be set. If your trial goes, we'll figure it out. Okay, anything else we need to address today?
Nothing from the state.
Nothing from the defense, Your Honor.
Okay, August the 8th for hearing on the motion to be set. And that's just on the motion to suppress for now.
I guess contingent on the state's position for the other two motions, which are very basic. Most of the legal argument, not evidentiary hearing. It'll probably be addressed on the same day.
Okay, State, you good?
Yes, sir. I can be prepared on all.
All right, sounds good. Thanks, guys. Give me 1 second, Mr. Moore.
Yes,